Hello, and welcome to Ethics and Retainer Agreements, Lawyers' Best Practice Risk Management Tools. My name is Jeffrey Cunningham. I'm a partner at Goldberg Segala LLP in White Plains, New York. Today we're going to talk about how attorneys can use the retainer agreements as risk management to limit potential liability, but also as a best practice tool to enhance their ethical practice. My practice is primarily based in defending attorneys and other professionals, but attorneys sued for malpractice or facing ethics issues. And I think retainer agreements are particularly important now during the COVID-19 era. But it really is the primary agreement between the attorney and client, and it's often neglected in that most attorneys utilize a retainer agreement, but then put it in the file and never look at it again until years later when there's a problem, and then it's pulled out, and by then the damage is completely done. Today we're going to be looking at the ABA model rules, which have been adopted in most jurisdictions, or in many jurisdictions to some extent, and a national perspective as we go through today. So a big picture view, retainer agreements, as I said, it's our best practice tool, but it's a risk management tool as well, in that making you a better lawyer makes you a safer lawyer, and clearly outlining the scope of the representation with your client, no matter what practice area you're involved in, reduces risk across the board and allows you to fulfill your ethical obligations in a far superior way. Retainer agreements, of course, are contracts. There's jurisdictional considerations. You have to know the law, and you have to know your state or states' bars rules, and think about not only where you practice, but where the client is also located, and any particular jurisdictional considerations should be addressed at the outset. You want to have a living retainer agreement, like the Constitution. For every client, for every matter, you should have a living retainer agreement. And a living retainer agreement is one that evolves along with the attorney-client relationship. You want to audit your firm's retainer agreements. It's not enough to just have a form retainer agreement. Even if, every client, every matter has a retainer agreement, that's not enough. You want it quarterly, annually, updated, reviewed. Make sure that the retainer agreement you're using isn't something that was drafted 20 years ago, isn't something that was drafted when your firm only handled med-mal defense matters, and now the firm is doing all sorts of other things, and the retainer agreement no longer fits. And from a very simple, practical standpoint, make sure it's the best possible contract you can be providing to your clients. It protects your firm, it protects the client, and it helps you fulfill your ethical obligations. So the retainer agreement audit is very underutilized and very, very important. And it can be a very quick process. It doesn't have to be anything substantial. It doesn't have to be anything time-consuming. But having a team in place that can do that and do it quickly and efficiently is really key. Before we dive into the specifics of retainer agreements, just want to talk about the big picture. Two targets we're looking at here are professional ethics, so attorneys' professional ideals that govern our conduct, and risk. And typically, risk to attorneys is legal malpractice and related claims, generally only from the client, although in certain situations, other claims are available to non-clients. But there's other risks that I want to think about today as well. Cyber risks, it's an ever-growing area of concern for attorneys and professional liability insurers. Business risks to attorneys, and specifically the COVID-19 related risks as well. Stepping back to ethics, we all know our jurisdictional rules of professional conduct. Typically, they are intentional acts, but not always. And usually it's a course of conduct. So it's not one error that can lead to ethics issues, but a repeated course of conduct. Whereas a claim against an attorney, particularly legal malpractice, can involve just one mistake. And of course, state bar rules and the model rules as adopted are particularly important. And it's, a bit more challenging these days in that the many states have adopted the model rules, but not in their entirety. So there's nuances between jurisdictions that you need to be aware of. Today we're going to discuss, the retainer agreement. It touches on every aspect of the attorney-client relationship, and it really hits on almost every rule in the model rules. But in particular, we're going to talk about most of Model Rule 1, Model Rule 3, Model Rule 5, 6, and Model Rule 2 as well. So we're going to be touching on those specifically, but again, the retainer agreement is the primary source of your attorney-client relationship, or at least you want it to be, and it really does cover the whole host of our ethical responsibilities to our clients.